PI show. My name's Harry Nowicki. I'm a personal injury lawyer. Here together with colleague Tony Carbone, who's another
Harry.
personal injury lawyer.
Good day, viewers.
And
Good
tonight
evening,
we're just talking about a number of court cases decided in one's in Victoria, one's in South Australia. Sorry, West Australia. Tony, but before we go to that, what's been in the news on personal injuries?
Well, Harry, in the news there's been a lot of stories about car accidents and things like that. And what's tragic is a single mum with 4 kids that was involved in a nasty car accident where a P-plater ran a stop sign and she was severely injured where she hit her head on the dashboard, left with impaired vision and 2 smashed knees. Now, one of the biggest concerns was who's going to drive her children to school. One of them's got cerebral palsy, was also very severely autistic. Now, the TAC have refused to pay for someone to take the children to school, a driver, and that's gone to VCAT. Now,
It's a tough case, Tony.
well, you might not be able to get the travelling expenses based on what the legislation says in terms of, because it's got to be her travel.
Her travel, yeah.
However,
they'll pay for her travel.
One of the things you looked at was, can you get it as a
Part of home
domestic service type thing, home help?
Yeah.
You know, because one of the duties is for her to pick up and drop off the children and vice versa. So I'm pretty confident that she'll probably succeed under a home help / domestic services type argument.
It's a borderline claim, Tony. I wouldn't be 100% confident. I mean, they're giving it a go, and I think depending on the facts, the court might look after her.
Well, she's a
I
single
mean, it's a
mum,
sympathetic
so
story, and got 4 kids, and it's got no one else to help her, and she needs some assistance.
well, I think she'll get it as a domestic / home help service.
We hope so.
Yeah,
We hope so.
And if she doesn't, I'm pretty confident that I'll amend the legislation at some point in time.
extend
beyond that.
Liability.
Harry, the other issue I want to raise is, whilst we're on the subject of motor vehicle accidents, it's the number of cyclists that have been killed on the roads. I'm talking about motorcyclists. And they had Ken Lays, the Chief Commissioner in relation to traffic operations, and we've had 40 motorcyclists killed on the road so far. And it's pretty big, and there's issues about what do they do to get better education on the road, or do they extend the current licensing regime in terms of
there's an issue,
training and
issue about training.
training's a big issue.
Is there an issue about clothing or helmet? I mean,
There's always been an issue about clothing.
There's an issue about
helmets are compulsory.
Compulsory.
I don't know if the jackets are compulsory. I know that it will go to the issue of recovery of damages if you don't have proper clothing.
Contributory negligence.
But the only thing I think is compulsory at the moment is a helmet. But I think they're looking at it at the moment. But also, how do they improve
the training and education.
Yeah. Because you come off a bike and you really don't have a lot of chances.
But I think somebody raised an issue where if somebody puts a bike away for 6 months, when they come back, they should get some training.
That's exactly right.
Yeah.
So, I mean, and you make one mistake on a bike and you really don't get a second chance, do you?
It can be fatal, and there are serious injuries.
And even if you don't die, there's always major injuries. Anyway, that's the topics, and we're with the police on that one, and we encourage better safety on the roads, I guess. That's the best way to put it. Now we're on this case.
Well, we got some court cases. One was decided by the Supreme Court in Victoria in March 2010 by a single judge, and the case was about an employee who, in effect, had a psychiatric injury, nervous breakdown, based on excessive consumption of alcohol and marijuana after hours on a job which required him to travel throughout Victoria, and I think some interstate travel as well.
And they were stationed at wherever they were working, and they were there for lengthy periods of time.
Yeah, I think it was down at
away from home.
Portland smelter for a long period. And the argument by the plaintiff was that it was foreseeable if the employer was on notice that he had some problems, and at least the court said he did grizzle about being away, and there was a culture where if a number of employees went, they would stay in a motel, they'd drink after hours.
There was a lot of boozing and marijuana smoking and all sorts of things.
After hours, and it was part of the job to go away. The employer organised all the living away from home
expenses
and things, and he ultimately, after 4 or 5 years, had a nervous breakdown and a psychiatric injury, And I thought the case could have gone either way, but the judge said the employer had no duty of care for someone who was drinking excessively after hours.
Where it was within his own capacity, basically, to look after his own safety.
Capacity, autonomy, he had a choice, he didn't have to drink, he didn't have to smoke marijuana to excess. Although there was a culture of mixing and mingling with other employees, and there was a big argument about whether the employer knew of what was going on.
I think the evidence was that the employer did know, Harry. And
I think it was in dispute, and I think there was arguments back and forward about whether the employer knew that when they went away, they were drinking, whether he was drinking and other people were drinking and smoking at the same time.
I'm confident he knew, and in any event, it stands to reason that when you're
foreseeable.
away, you don't know anyone, so you're generally hanging around with the same group of people you're working with. And that's what he was doing in this case. And the culture was drink and smoke pot.
To excess.
So, and I'm pretty confident the employer knew this. I just think that...
well, look, I think he did grizzle about being away. I don't know what grizzling really means, but that's what the judge characterised it as. And then, but the judge ultimately said it wasn't foreseeable. The employer couldn't foresee that he'd have a nervous breakdown based on him just being away from family, being sort of isolated, drinking to excess, and
it's almost like an extension of that Kohler decision, Harry. You know, that psychiatric case.
Well, the case went to the High Court on someone in West Australia having excessive work hours, and then she had a nervous breakdown.
But in that case, there was no evidence about the employer knowing that she was suffering stress.
The employer didn't know she was suffering psychological injury. She had chronic pain. She had a chronic pain syndrome in the end.
The employer didn't have a clue that she was stressed and...
No, the employer wasn't on notice.
No, she'd never said anything.
And the High Court said that it wasn't foreseeable that the employer was on notice.
Well, what's important is that you've got to make complaints. That's basically what the Kohler case says. If you don't make complaints, the employer doesn't know. Look, we've got to go to a sponsors break, Harry, so just like time just flies as usual.
Just flies. Okay, we'll be back.
Viewers, don't go away. Stay tuned. We'll be back very shortly. Thank you.